All right, welcome once again to the University of New Mexico Law and Mental Health series. This is a series hosted by the University of New Mexico Department of Psychiatry and Behavioral Sciences and the New Mexico Behavioral Health Services Division. We're excited to have so many of you here today. I'm Dr. Anthony Perillo. I'm the Forensic Psychology Training Director here at the Department of Psychiatry and Behavioral Sciences in the University of New Mexico. Just a couple of things for our talk today. Just if you have any questions, you'll see at the bottom of your Zoom app the Q&A box. That is the box that you would enter any questions into. Feel free to enter anything anytime you feel comfortable. We will hold off on responding to those questions until the end. We try to give as many as possible to our presenters. Just forgive us if we can't get to yours. For those of you that want continuing education credits, you do have to stay for the full hour, but you do not have to stay longer than that. For those that are seeking medical education credits, there will be a sign-in sheet that is going to be in the chat shortly. For those of you that are seeking APA continuing education credits, around the last 5 minutes or so of the talk, there will be a link that gives you a survey that you'll complete to then receive your credits. Make sure you open that link before you close the seminar today, and make sure you save your certificate. We can't access those, so we won't be able to get them to you after the fact. For next week's talks, we'll have Dr. Sean Akecheson talking about concussion as a mitigating factor in capital murder. But that's for next week. This week, I'm going to introduce you to our two presenters here. I'm thrilled to be able to introduce you to Dr. Lucy Guarnera and Dr. Daniel Murrie. Dr. Lucy Guarnera is a licensed psychologist and assistant professor of psychiatry and neurobehavioral sciences at the University of Virginia Institute of Law, Psychiatry, and Public Policy. Her research seeks to improve fairness and accuracy of the justice system, both through studying biased decision-making among experts and investigating the legal experiences of vulnerable individuals. Her research on the legal experiences of women who became pregnant from rape has been honored with the Best Dissertation Award and multiple grants from the American Psychology Law Society and the American Academy of Forensic Psychology. As a clinician, she trained in empirically based assessment and treatment of traumatic stress at the National Crime Victims Research and Treatment Center at the Medical University of South Carolina. She also completed a Forensic Postdoctoral Fellowship at the University of Virginia. She currently conducts a wide variety of forensic evaluations with an emphasis on interpersonal violence and traumatic stress. Dr. Daniel Murrie serves as the Associate Director of the Institute of Law, Psychiatry, and Public Policy and professor in the Department of Psychiatry and Neurobehavioral Sciences at the University of Virginia School of Medicine. He directs the UVA Forensic Clinic, the UVA Postdoctoral Fellowship in Forensic Psychology, and the statewide training program for psychologists and psychiatrists learning to perform court-ordered forensic evaluation. As a forensic psychologist, Dr. Murrie performs a variety of criminal and civil forensic evaluations addressing capital sentencing, adjudicative competence, legal sanity, risk assessment, psychological injury. The list goes on. Nationally, he consults with state administrators and serves as a federally appointed monitor to help states improve their forensic service systems. As a researcher, he's co-authored over 70 peer-reviewed scientific publications, 3 books, numerous book chapters, all addressing forms of forensic mental health evaluation. And much of his work has consisted of research addressing reliability and bias in forensic evaluations. Dr. Murrie is also the president-elect of the American Psychology Law Society of Division 41 of APA. Dr. Guarnera, Dr. Murrie, it's a thrill and honor to have both of you here. Can't wait to hear you talk about evaluating evaluations. I will throw it to you now.
All right, thanks so much, Anthony. We had to talk about not really needing to read those bios because they're on there, but we do appreciate that. And we really appreciate this seminar. I would often tell Julie, and I'm certainly told Anthony, that this is just a gift to the field. I mean, it is a great service to the field, and there has been some wonderful talks here. So we're honored to be part of it. We think of ourselves as consumers of these talks, and are happy to be involved on this end as well. So we want to talk about this scenario that probably all of you have been in, where you're asked to evaluate an evaluation or to address someone else's work. I think this was born out of a talk that the two of us had, where we realized this was starting to be more and more of our work, was simply reviewing other work. And we realized that there didn't seem to be set guidelines or parameters on that we were just sort of approaching it really kind of according to our own style or preference. And so we wanted to kind of move not to any kind of full guidelines or protocol. I want to be clear that we are not presenting that, but we did want to try to solidify our thoughts a bit. So that's what we'll be addressing today. Let me move quickly through this. The CE instructions you have. We have nothing really to disclose here. And of course, these are only our views. Learning objectives, we will really sort of blend these throughout. One is we want to start with the idea that there are sources and guidance for critique. It's not a free-for-all. We'll talk through some examples and describe our process. And in doing all of this, we'll talk about sources of bias and bias control strategies. So this really isn't an agenda here so much as some objectives that we think are blended in. So I'll ask you to think a little bit about the context for reviews. When and why are you reviewing other work? Some of you may have jobs that require this. You're a supervisor, you run a state quality control program or your hospital's quality control program. I'm not really talking about those scenarios. I'm really talking about when as part of litigation, you are asked to review someone else's work. And this is, this happens in some pretty specific context. Maybe the most general and least pressured is just sort of a quality review consultation, right? Doc, are there problems here? Take a look at this report, tell me what you think. I'm an attorney who doesn't really know as much about this, so help me kind of kick the tires on this. That's probably the least contextual pressure one can have, but probably there is a hint of future work or an expectation that there may be something wrong. Perhaps more often is something that's explicitly adversarial, right? Retained by one side to review the work of the other side. And that's a very, very common scenario. There's also some that relate to habeas or appeals. I do a lot of capital work, and a chunk of that is habeas. Will you look at these past evaluations? We would like to know if there's something wrong with them. And that may relate to something like a particular line of appeal, often a claim of ineffective assistance of counsel. Now there are, a few other scenarios. Like one is what I'll call the neutral tiebreaker, and I think this has probably happened once ever in my career, right? Where a judge says, "Look, I've got two opposing reports, and I just need somebody to help me make sense of them, help me to kind of gauge the quality of each." That was a lovely scenario. It's really ideal. But when you think about these other three scenarios here, there's a certain kind of contextual pressure to them. There is some push or pull, right? There's maybe some kind of expectancy effects, the idea that there will be something wrong there and you just have to find it. The idea that it doesn't fit a particular theory of the case and you want to see why that is, and you're asked to, essentially, fulfill an attorney's hopes, that there might be problems in that first evaluation. And this can all kind of tie into this phenomena we call adversarial allegiance, right? A pull to find what the retaining party is hoping you find. But there's other pressures too here, and one is this one we're calling self-enhancement. Maybe a kind of implicit pressure to look smarter or better than the other evaluator, to find a chink or a flaw. I don't know that any of us, when we do this work, very often say, "Hey, you know what? That was a great evaluation. It was actually a lot better than I could have done. She did an amazing job. Nothing to say here, right? That's really uncommon. And I think part of that is because most evaluations have something to address. But part of that is because there's a lot of pressure in this scenario to really look like the expert who found flaws in another expert. And I worry that can sometimes skew process and tone in ways that we'll talk about later. And Lucy also made the good point that there may be almost the opposite, sort of a self-protection effects, right? There may be times that we see practice that isn't actually ideal, but we realize we are maybe guilty of the same shortcomings and don't want to draw attention to those. So we cut some slack there. But I say all of this to say that we go into this work with quite a lot of pushes and pulls, quite a lot of pressure, what we call contextual effects or contextual pressures. So one of the starting points is what is even fair game to critique? And some of you have struggled with this kind of thing as supervisors. Often when you're supervising a trainee report, you think, this isn't really how I would have written it. But it's not necessarily wrong. It's just a different style. And there's some scenarios also where you think like, well, reasonable professionals can disagree on this point. The field is not entirely clear here. Just because I might do that a little bit differently doesn't necessarily mean it's wrong. So there are really, I think there's a lot that could be pretty petty that I would argue we don't necessarily need to critique, right? It's not a matter of right or wrong or falling far short of practice standards. I'd also argue that maybe we don't do a lot of broad or vague criticisms. The focus in all of this, it probably needs to be a failure to meet a true practice standard, falling well short of best practices, falling short of what competent, conscientious professionals would generally agree on doing. Which of course raises the question, how do we exactly know that, right? Our own practice is not, it's not necessarily the plumb line for good practice or best practice. And so what do we need? We need some kind of fixed reference points. And we'll argue that basically going into any review of someone else's work needs to start not so much with what do I prefer or what do I do, but generally, what does the field agree upon? And where do we get that? Through a number of sources, right? There are ethical principles for psychologists from the APA. We know that there are ways in which these are not formal binding rules, but they do really reflect the values of our profession. And I think even more so the specialty guidelines for forensic psychology. These have some really important principles. And frankly, I think many of the problems we see in forensic reports are in some ways violations of the key principles we see in the SGFP. So at least in my experience, which certainly may be atypical, much of the work is just sort of citing chapter and verse of the SGFP, right? How does a particular evaluation or report not really line up with this? I see this as really helpful for some broad principles. Same with certain texts you all know. The Melton text, I think many of us would think of as the kind of classic and most authoritative. It is an important source. I would argue the same for these Oxford Best Practice series. These really were meant to kind of distill best practices and particular kinds of evaluations. They're not binding regulations, of course, right? But they are descriptions of recommended practice for particular types of evaluations, written by authorities in those particular evaluations and vetted by a panel of other experts. So might there be a time a good evaluation doesn't square 100% with this? Perhaps, but generally these are going to be really good guidelines. Psychiatrists have the same from the American Academy of Psychiatry and Law. And of course, we as psychologists can benefit from these quite a bit. Most of our practice should probably comport with these, even if we're not psychiatrists, because so many of the principles illuminated here are really reasonable, appropriate guidance for forensic evaluation. And of course, there's other authoritative text, each of which have some strengths and limitations, but these are important. Certainly when we're addressing how a test is used or interpreted, we want to think about the instrument manual as a source, perhaps research around that test or instrument. And there are other topic-specific text. A very narrow type of evaluation might have a specific text for it that's far less well known than Melton, but it might be relevant. But I think it does call for kind of a fair appraisal of what is truly authoritative versus one particular perspective on an issue. You can think of some texts that are not so even-handed, right? But they're arguing a particular perspective on a particular type of work, and reviewing with those as your plumb line requires a certain honesty, right? And saying, no, this isn't necessarily widely accepted, or it's one of two competing perspectives, and so you don't want to be cherry picking, only the one that sort of fits your perspective.
All right, so now that we've got a sense of all the kind of context bringing us into these evaluations, what do you actually do when you're evaluating an evaluation? So we've got a couple steps to kind of guide your way. So, and as I'll mention in a second, these are not necessarily in order. So one thing you need to do is, review those relevant and authoritative sources that we just went through that are the most relevant to the particular kind of evaluation that you're looking at. Review all underlying materials. So that could be, lots of different things: the original records, the notes that the psychologist took on their interview, their notes with collaterals, their testing data, including potentially the, you're checking addition, checking things like that, all the way down to the kind of base level of the data that's being used to form the scaffold of their opinions. There are many situations we both encountered where what makes into the report is very different from what's in the materials that underlie the report. And so when you dig down, you can sometimes find, serious concerns or problems or weaknesses that wouldn't initially be apparent if you were just going off of what the report says. So that can include, errors in, like I said, simple addition errors, errors in administration or interpretation of tests, cherry picking or kind of ignoring or leaving out or downplaying potentially contradictory information that's, there for all to see if you read the interview notes, but may not make it into the report, things like that. So then reviewing the actual report, of course, because that's going to be laying out the other evaluators' opinions and the reasons and bases for their opinions, and also like limitations for their opinions. So these are all important things when we're looking at what they're actually saying and whether it can be supported or not. In some reviews of evaluations, you might have testimony by the evaluator in a deposition or other kind of legal hearing. And so that can be very relevant as well. Sometimes they kind of may fill in the gaps or answer questions that are kind of left open-ended. If you're just looking at the reports, you can get more information from there about what they were thinking, the methods and materials they used, really where these opinions came from and how they're being supported. And then last, you're going to author, your own report, likely, if that's required by or requested by the referring party. And so this is going to look a little bit different from, a typical forensic report. There's going to be different sections, different focus when you're not doing a clinical evaluation of a person. And so I don't think there is sort of a standard, this is how you've got to do it. But the two most important things that we came to for when you're writing the report is Number one, to choose kind of key concerns or violations. So we talk about them as sort of like themes. And, that should be a pretty limited number, maybe 2 to 5, something like that. And these should really be the most important things, for good writing and for clarity and communication. We don't want to be just picking every single thing that kind of bugs us about the report or could be an issue or could be a problem. It really needs to be the kind of heavy hitters of what's most important. And then in your own report, you want to be citing those authoritative references. So if you say, hey, there's a problem here, here's why, and show it and explain it. Because attorneys and other folks in the legal system, they're not going to be familiar with this, and they're not going to know what's important and what's not out of a bunch of potential errors. And so, we have made it a practice to really, put in direct quotes, block quotes from the SGFP or from the, APA ethics code or whatever it might be to kind of point out the deficiencies and explain why we are concerned. So we said we would talk a bit about kind of bias control and our ways to limit bias or kind of deal with bias. Dan already presented many sources of bias you might have coming into an assessment, like the expectation that you're going to find problems. Here is one way to think about a way to kind of limit or control that bias. So y'all may or may not be familiar with this idea of linear sequential unmasking. So it had its origins really into the forensic sciences. So things like, fingerprints and tire treads and things like that, where, in the last 15, 20 years or so, more and more evidence has been coming out that there are very strong contextual effects, where if you're a fingerprint matcher, I shouldn't say matching, but if you're a fingerprint analyst and you've been given 2 fingerprints and, your goal is to say whether they, could have come from the same source, and for a fact that one of them is from the suspect that's in custody, that the police are really hoping you can give them evidence to kind of put the nail in the coffin there, then there are really strong contextual effects for you to find similarities that maybe wouldn't be there if you didn't know that, this fingerprint belongs to this guy in custody that police are hoping to get. And so this idea, as it applies to forensic science, is, hey, let's order and control the flow of information so that you're not biased too early by things that are not relevant to that stage of the evaluation. So that's why it's linear and sequential. So it has an order, it's linear, sequential, one thing after another, and unmasking, if you do get to see all the information, but it's in a particular order to kind of limit or control your bias. So for fingerprints, you would look at just the prints themselves first before you knew anything else about the case, anything about where they came from, anything else about that at all. We just want to start with those basic observations of what is the base level of similarity before I have those contextual effects working on me. So as this applies to evaluating evaluations, the way we've thought about it is that the ideal setup, what happens a lot is the attorney sends you a report and says, hey, doc, look at the report. That's actually not the greatest order to start with. Ideally, you would start with the raw materials. You would start with the records and the interview notes and the collateral notes and the testing. And you would look at those first before you've seen the other evaluators' final opinions as they've written them up in the report. Because that way you're starting at the observation level. So you can see what you would have drawn, what conclusions you would have drawn, how far you'd be able to go, or what you'd be able to say based just on that raw information. And I would encourage you to kind of to commit to it a bit, like write it down. Because there is a tendency, when we do that unmasking, where then you get to read the report next, you might say, oh yeah, I saw that problem all along, when really originally it didn't seem like a problem. It's maybe just this pressure to find faults or please the attorney or whatever it might be. So start with the raw materials, then unmask the report. And then if there is testimony, unmask the testimony, since that's kind of building on top of and clarifying things that might be in the report. So we don't have any research on this. It would be fascinating to see how it works. It's just a method that's been used in other fields as a way to kind of think about how we might limit or control bias. And kind of last, but very important for this process, don't go beyond your own referral question. So typically in these contexts, you're being asked to comment on what someone else did. You're not being asked to come to your own conclusion about the person's clinical status, the sort of correct answer, or ground truth about whether someone was competent or not, or has PTSD or not, or whatever it might be, because you didn't conduct the evaluation, and there's often a lot of things you won't know. As we'll show, a lot of the problems are things that weren't done, and so you don't have enough information. So that this maxim here of absence of evidence is not evidence of absence is really important, and something that needs to be emphasized, because I think it's easy for lawyers to kind of switch that up. You can say, hey, they didn't do the methods were not sufficient to show that this person meets the insanity defense. But that's very different from saying this person does not meet the insanity defense, which you likely won't be able to do as someone who's just reviewing written material, someone who's not doing an evaluation yourself. So this is something to keep in mind all the way through.
Great. So we sort of summarized what we see as some pretty common scenarios in forensic evaluations. We called them the 7 deadly sins. We spent a little bit of time really trying to match them up with envy and greed and wrath, and then we kind of fell apart with lust and some of the other sins, so that we can't stretch the metaphor as much as we wanted to. But there do seem to be common themes that come up. And again, this is not all that different from some of the common errors you will see written in other sources, right? So there was a paper many years ago that reviewed some of the ABEP work samples and said, hey, here are the most common errors, even among people applying for this strict credential. And we'll see some same things here, going beyond the referral question or answering more than was asked, answering questions that were not asked. That's a key forensic sin, if you will, and it's also really common. Adding irrelevant or prejudicial information. And again, by prejudicial, I don't mean bad about the defendant or the litigant, right? There's plenty times where bad or unflattering information is absolutely germane to the referral question. What I'm talking about are scenarios where that information is irrelevant, it's gratuitous, and is perhaps even distracting or misleading from the referral question. One of the things we say to trainees around here is like, just because he said it doesn't mean you have to write it. There is sometimes a tendency for evaluators to just put everything they've been exposed to or everything the defendant or litigant said without really stopping to think what's germane to the referral question, what's responsive and relevant. And there are times that's just sort of a nuisance, and there's times that actually does damage. It's actually poor practice, and that warrants attention. Failure to use sufficient collaterals, the right collaterals, or adequately review records. Failure to make use of what's in the records. Being overly selective or apparently biased in what is drawn from the records. If we have time, I'll talk about a case in which there were 4 IQ scores in the historical records. All were easily discoverable in those records. They were clear, they were credible, conducted by school psychologists and others. But in this evaluator's report, the evaluator only mentioned the score that was well above 70, did not mention 3 scores that were below 70. That is an error, right, of some sort in how the records are used. Errors in selection and interpretation of tests, using tests that aren't appropriate, or using them in ways that aren't appropriate, or drawing conclusions that go far beyond the test results or even discrepant to the test results. Failure to acknowledge contradictory evidence or the limits of self-report, the possibility of impression management, and then failure to distinguish observation from inference, failure to connect evidence to conclusions or explain reasoning. This, in studies of report quality is the one error that tends to be identified most, right? Sort of reporting symptoms and then a psycholegal conclusion, reporting exposure to trauma and then a PTSD diagnosis without anything to link the two. So those are common errors that come up. One, though, I feel like a key one that I'm just always struck by is evaluators going out on a limb further than that limb can support, going out saying more than really the data can support, and sometimes in ways that really seem to harm the case overall. So there are many scenarios in which there is much for an evaluator to say, even regardless of which side that evaluator is on, right? There is much there that is relevant to the referral question. There are many evaluations where mental illness is present in a defendant that could be very much mitigating. It could shed light on mental state. It's certainly there, but evaluators may be prone to go much further than the data can support, and then that leaves them vulnerable, right? There was something helpful to say there, but because you said too much, now credibility is shot. I'll give you a silly example of this that comes to mind. This was a case where an evaluator administered a psychopathy checklist in a type of case where psychopathy wasn't really relevant. It wouldn't be typical to give that measure. Not relevant, not really appropriate. But gave it, I suspect with the idea of mitigation, showing that this person is very, very low in psychopathy, and therefore that should be considered mitigating. And so the person did the psychopathy checklist unnecessarily, scored a lot of zeros, assigned an overall score of 2 or 4 or something just statistically really unusual for the degree to which it was low. And then, of course, that just invites analysis, right? Had this person never done a PCL, I wouldn't have thought a thing of it. I'm shocked that they did it. But of course, when they do it and score it, then I have to review that and see just some really strange scoring, right? Somebody got a 0 on sexual promiscuity, but regularly went to prostitutes. Somebody got zeros on things for which the data just patently contradicted that scoring. And so then it really invited rebuttal on things that really never would have been at issue to begin with, but because there was such a strong assertion, it just sort of called for correction, and that never would have happened if there wasn't this effort to go far beyond what was necessary to the case, or say more than what was relevant. So that seems to be a common risk in this kind of work, and I think probably is really important as we are doing our own work, right? Is what we're concluding going beyond what's available, and those sort of instances are always nice cautions for me in my head. We've talked about what can be critiqued, and we'll walk through that more with some examples. But I also want to mention the style of critique. How does one critique? How does one disagree with a colleague? And I like to imagine there is a certain etiquette here, or certain rules of the game. This is harder for me to imagine in this era, right? I can't really anymore refer to like disagreeing politicians having civil discourse, or some of the other examples we might pull historically from social context. But I do like to think there is an etiquette among colleagues. One example might be, journal article reviews. Some of you read articles that kind of critique the methodology in a prior article, or the conclusions in a prior article. And generally, there is sort of a decorum to those, and there's a professionalism to those. There's a focus on the actual methods and issues. They're not ad hominem attacks on the researchers usually. There's kind of a right way to do this, right? I want to use the word charitable, but it's not really charitable in sort of overlooking flaws or errors. But I think the tone really matters, and maybe the most important piece of this, I think, would be to just avoid ad hominem. Addressing the methods in the report and not the evaluator. Partly because this is kind of a do unto others, right? This is kind of what you would want others to do, but partly because I think you can just sound ridiculous with ad hominem. I think I I can think of some scenarios, and again, maybe these are familiar to you all, where the critique will go something like, "This is the worst evaluator ever. This is ridiculous. I can't believe this person has a license. They have no business doing this work at all." And this stuff, it feels very hyperbolic to me. And this is not to say that there aren't grave and consequential errors in reports that we should vigorously address. I mean, that is right to correct what's there. But this sort of tone of outrage, it sometimes sounds very self-righteous. It sometimes sounds very over the top. You know, there's all sorts of like mediocre substandard practice that doesn't really mean somebody's license will be taken away. So these kind of over the top statements, they always feel like a bit much. And I believe, I theorize, I don't know this is true, but I sort of think it hurts the credibility of the criticizer. That if we sound just completely outraged and dramatic, it somehow probably hurts our credibility. Again, I have no research to support that. I don't know that to be true, but I suspect it may be. And so one of the things one of the ways we try to frame this is just teaching. You know, rather than me saying that Dr. Jones is just terrible and just outrageously poor, I think it makes a lot more sense to say, hey, look, here's kind of the standard methods, here's the best practices for the type of evaluation Dr. Jones did. Let's see how they match up. You know, let me kind of put this out before you, judge or attorney, and kind of let you walk through it. Now, maybe, you know, there are, as we were kicking this around, we agreed like, okay, there could be some things that are so egregious that they do warrant a complaint to the Board of Psychology or Board of Medicine. I don't want to say that could never happen. You know, there may be times where that's appropriate. There may be times, and I think we both encountered this, when evaluators are practicing beyond their training or competence, right? Doing things they've truly never had no training to do. And I don't just mean you know, like given X instrument without having gone to the gold standard 2-day workshop on it. You know, I mean like actually offering opinions or services that they don't have the qualifications to do. And that's totally fair game to address. I'm not saying to like downplay any of that. But I think our tone and critique really, really matters, particularly in reports and testimony.
And something last thing to be thinking about is, I think we both found that critiquing others' reports can and does improve your own clinical practice, thinking and writing. I have definitely found that to be the case. You know, as I'm thinking about like, all right, you know, there's this contradictory bit of information, but I don't really think it's that important. Do I want to bother to explain this? Well, thinking about, hey, if somebody's going to review my report and get my underlying materials and see my interview notes, you know, I better acknowledge that and I better explain it. So I think it kind of curbs lazy or bad practice, and it can, you know, and looking for faults or errors in others, you can see them more in yourself. So it has a benefit for you as well to do this kind of work. Okay, so we're going to go through some case examples now. I'm going to start by talking about a civil litigation for psychological injury for PTSD, and couple caveats first, I guess. So number one, with this case example, the point is not to kind of like bash this report, and I hope that's not the you know, the tone that you get off of me here. I picked this one because I think that the errors or concerns of this report, and there were a lot, are very typical of what you commonly see. They really are some of those 7 deadly sins. So I think it's helpful for teaching in that way. Another caveat is that this is what I did. You know, this is not necessarily the perfect thing that everybody should do. And I am very open to, you know, your comments or thoughts about, I don't know if that tone was right, or if that was, maybe that theme wasn't important enough to mention or something like that. I am very, very open to that. Another thing is that, yeah, I selected this because I think there were a lot of those contextual pressures that I could feel and talk about, where number one, it was a report with a lot of errors or flaws that I think were pretty severe and undermine the conclusions, you know, spoiler alert. But number two was one where I could feel a lot of compassion and concern for the evaluee. It was someone where I really thought, hey, they might actually have had PTSD as a result of what this company did. It was kind of an employment lawsuit against a company that caused PTSD through their actions. Like, it seemed pretty plausible to me. I think he might have had PTSD because of this. I think he might have had a case, and it was sort of sad to read these things. But the report that was arguing he did was just not sufficient. So I kind of had these pushes and pulls of, hey, I need to be honest about the flaws, but I don't want to overstate, what I can know or not know, because I think he might have a case here. It's just that this report wasn't doing it. And the last thing to note is that I know talking about sin, the original sin of PowerPoint is putting too many words on there. I totally get that and try to avoid it. When we're talking about using authoritative sources, tone and style of writing, I didn't really know a way to do it without including examples of what I actually wrote. And so I am not going to read everything. It's up there for if you want to review more after, but there are a lot of words. I'm just warning you in advance. Okay, so start with things I want to highlight are, number one, the use of themes. So I numbered them. So concern one, Dr. Doe's definition of complex PTSD is plainly incorrect. So we had diagnosed complex PTSD. So important thing here is calling on an authoritative source. So if you're going to talk about complex PTSD, the only, authoritative diagnostic classification that has it right now is the ICD-11. So you need to talk about that. So I talk about, hey, in the ICD-11, complex PTSD is like PTSD plus. You have to have all the stuff for PTSD, and then you have extra stuff as well. And this evaluator argued the opposite, saying the person didn't meet criteria for PTSD, but they did meet criteria for complex PTSD, which is not possible logically. But again, giving these caveats and not going beyond what I can actually say, I said, hey, to be clear, it may be a matter of debate whether his experiences at the company as he described them would meet the definition of a traumatic event. So, hey, he could still get PTSD or complex PTSD. I'm not ruling that out. I'm just saying the way that this is being described is not logically possible. So concern two, Dr. Doe provides insufficient evidence for a current PTSD diagnosis. So this is the failure to connect evidence to conclusions or observation to inference. So starting out with some kind of authoritative journal citations of saying, hey, trauma doesn't always lead to PTSD. In fact, it usually doesn't. And the reason I'm saying this is that you need to show that trauma resulted in these specific symptoms that constitute PTSD. It's not enough to just say, hey, the person had trauma, therefore they had PTSD. And this is an area you see in a lot of psychological injury reports. So starting with these kind of authoritative sources, explaining the science of why you need to do this, and then going into what the kind of the concerns were of there was really no discussion at all about symptoms of PTSD anywhere, even though, they did an interview, there was lots of time, they could have done testing, and it didn't really happen. And so when I look at the deposition, this becomes even more clear. So looking at testimony, Dr. Doe acknowledges that he, quote, did not actually set forth the DSM-5 criteria, diagnostic criteria for PTSD. So when you kind of dig further, hey, he's even kind of saying, I didn't do this, and I need to explain why it's important. Concern 4, I think I skipped a number, my bad. Technically 3, whatever. So there's only 5 concerns, don't worry. I thought I had 6, that's good, too many. Okay, concern 4. So all 4 psychological tests Dr. Doe administered are misinterpreted or otherwise misrepresented, and so don't support his conclusion. So this is, again, common error is problems with testing, and it really only became clear when you're digging down into the raw testing materials. So don't worry, this is not anybody's actual PAI scores. What you're seeing here is this red squiggly line that I drew is a rough representation of Mr. X's PAI scores, which were basically normal. Like there was no problems at all. It was all in the normal range. And so what Dr. Doe did is that they applied the PTSD overlay, which in actuality is just average scores of a normative group of only people at PTSD. So those are the black bars here, the black lines. And as you can see, they're much higher than average. They're much higher than T = 50. Makes sense. These are people with PTSD. The concern was that Dr. Doe mistakenly believed that the overlay was a kind of reinterpretation of the individual's scores when compared to the PTSD group. So he's saying, hey, when you compare them to the PTSD group, Mr. X has a lot of problems. So of course, that's the opposite of the way that it goes. If you're at, pretty much average compared to the average population, if you're being compared to people who have a lot of psychopathology, you're going to be even lower than that. So this took a lot of teaching and explaining, because these are not ideas or concepts, T-scores and statistics and overlays that anybody in the legal system is going to understand. But you can't just say, hey, he's wrong and I'm right, because why should they believe that? So there was a lot of sort of careful, hey, this is what you need to know to get far enough to kind of understand the errors or concerns here. And again, another caveat, because I don't want to go beyond, and I think this guy might really have PTSD. So, hey, given Mr. X's tendency to deny problems on the PAI, he had an elevated PIM, it's certainly possible that he underreported his PTSD symptoms on the PAI. So, hey, even if he has average PAI scores, he could still have concerns. It's also possible that he previously had PTSD symptoms that dissipated after he quit the company that was causing his problems. So in other words, his normal PAI results do not make it impossible that he has or previously had PTSD, but neither are they consistent with a PTSD diagnosis, as Dr. Doe argued. So not going beyond my own referral question, not saying you can't have had PTSD and have normal PAI results, but they don't support a PTSD diagnosis, which is what the doctor said. Okay, concern 4, here we go. Dr. Doe does not adequately query Mr. X's mental health history or trauma history. So starting with quoting authoritative sources from Milton, the kind of Bible of forensic evaluation, you may not be super familiar with psychological injury evaluations. They're a little bit more unusual or specialized, but there are specific guidelines on how they need to be done. And so I'm not going to read this direct quote from Milton, but explaining that, hey, in order to say this injury, this event caused this psychological problem, you've got to address what happened before and after. Did the person have other traumatic events that might have caused the problem, not what you're suing for? And did this person have pre-existing mental health problems that might have preceded the event you're suing for, and that could explain what you're observing now? So you can't just say, hey, they had a trauma, hey, they had PTSD, therefore their suit is valid. You've got to ask about other potential contributors. And this was not done. So again, quoting that authoritative source, go into the deposition. Again, this kind of clears it up. When asked if he considered any other possible causes, the doctor said no. I'm gonna skip a little bit here. Concern 5, Dr. Doe is overly credulous of Mr. X's account and does not adequately acknowledge opposing perspectives. So this is going right back to our 7 deadly sins here of acknowledging contradictory evidence and not taking kind of a partisan view of your evaluee, expecting that, hey, there might be impression management, things like that. So again, starting with that authoritative source, going to Milton. And this one I will read because I think it's really helpful for everybody and something you can, crib for your future evaluations of evaluations. So Milton says, in therapeutic encounters, the clinician's primary interest is the patient's perspective, revealed gradually and more candidly over the course of repeated contacts during treatment, and kind of goes on. But the patient's perspective is primary. In contrast, the legal system is interested in the just adjudication of disputes, and accuracy is therefore the primary focus in forensic assessments. So many forensic assessments, considerations of alternate views, and the need to corroborate examinee or litigant reports make the examinee's unique perspective of only secondary importance. So that was really kind of the key sentence here of what I wanted to communicate about what the problem was in this report, which was that, hey, Mr. X reported this traumatic event at his company, but there's actually lots of depositions from other folks at the company who said this didn't happen or happened a different way. And so Dr. Doe read those, but never mentioned them or never talked about them in the report. They were in his list of sources, but they were never discussed. And this got cleared up again, even more if you go to the deposition. These are, his exact words. I am taking Mr. X's comments at face value because my job in this situation was to do an evaluation of Mr. X from his internal, personal, subjective experience. So unfortunately, that's really the opposite of what you want to be doing in a forensic evaluation, but you need to explain where that's coming from and why we don't just care about what the individual has to say and why this is a problem for the evaluation. So I also ended up citing another authoritative source, the specialty guidelines, talking about, hey, when we're relying on data that hasn't been corroborated, we make that clear. We're transparent about what's corroborated and what isn't. Talk about strengths and limitations and reasons for relying upon the data. And so I talked about that clearly of like, hey, these other people contradicted his report. Doesn't mean that they're right and he's wrong. I mean, he's suing them. It would make sense for people to lie or cover things up. that, don't want to go beyond what we can say here, but it needed to be acknowledged that there were multiple conflicting accounts of what went down at the company. Here's my, here's my written out caveat for you to look at later and see if you like the phrasing or not. Quoting here from Apple saying, hey, the biases of various reporters should also be considered. I think that's a mistake we can make of, oh, a collateral said it, therefore they're right. Collaterals have their own biases too. We need to be looking at everything. And then last things I'll say here, concern 6, he goes outside the bounds of psychological expertise. So going to that authoritative source, quoting the APA ethics code, we can only do things within our competence. And so at the end of the report, Dr. Doe analyzed handwriting to say that that most likely one letter was from a particular person and not from the person that it was signed by. So this is sort of like handwriting pattern matching, like forensic matching, which is not really possible for anybody. There's a lot of issues with pattern matching anyway, and definitely not possible for a forensic psychologist because we have no training in this at all. So that's sort of an easy one of that's clearly beyond the bounds of what we can do and was not acceptable. It was also not an opinion that was requested. So that's another one of going beyond the referral question. This was something kind of extra that he threw in because he felt it was important, but it's just not supportable. And so I'll end here with a final caveat yet again at the end of my report, just kind of underlying. I've said it a million times, but I didn't want to leave the impression that he couldn't have PTSD. So finally, I wish to state again in the strongest possible terms that this letter should not be construed to imply that Mr. X does not or could not have had PTSD or other psychological problems as a result of his reported experiences at the company. And so that was bolded in my report because I think it's so easy to make this mistake of, because the opinion wasn't supported, it meant he doesn't have PTSD, and that's just not true. He might have had PTSD. He might have a case here. My only opinion is that the methods are insufficient to come to this conclusion, blah, blah, blah. And, again, I don't think my retaining attorney loved this, but I felt compelled to put it in here of, hey, in other words, just because Dr. Doe failed to persuasively establish a PTSD diagnosis linked to Mr. X's experiences in the company does not mean that a different evaluation with improved procedures would be unable to do so. And so that's, these kinds of caveats are methods that I try to use to be clear, to be honest, to be transparent, and also to mitigate that potential bias to just go, full steam ahead and criticize everything, which can be misinterpreted. So I hope that was helpful. I'm going to switch over to Dan now, who's going to talk about a couple of habeas cases.
All right, thanks, Lucy. One of the things I think that's so sobering about this that I hope kind of came through in this last discussion is just how bad practice really can hinder justice, right? So this may well have been a litigant who had PTSD, who deserved compensation from a company who had done him wrong. I don't know, right? But that may well have been the case. But because that first evaluation was so bad, that evaluator, by doing bad practice, actually kind of hurt this litigant's chances of potentially getting something that was deserved. When they get a kind of second opinion evaluation from Dr. Guarnera here, and she kind of reveals these errors, that first evaluation has really become useless. I think she's has like great integrity in saying, hey, this doesn't mean you can conclude the opposite, right? You see that work to be very, very careful about what can or can't be concluded. But the original bad practice may well have really harmed a just outcome for this person. We just don't know. And I think had Lucy not been so careful, it would have been sort of, that would have been a form of bad practice, right? To just sort of go for the jugular here without acknowledging the limitations, being sort of agnostic about the actual legal issue, right? This is a review of the methods, not an opinion on the legal issue at hand. So I want to shift to capital habeas. I think that first civil litigation is a really common example of where this work occurs. Capital habeas is sort of a strange niche example of where this work occurs. But I think there's a lot we can learn from it. And the main point I want to make here is not to go into great detail on a case. You'll notice we're trying to be pretty careful and generic in using case examples that are viewed by 500-600 people. But just to kind of give a setup of what might be helpful in this type of work and probably others. And the bottom line here is I think we want to think about teaching, not just criticizing. And so we essentially want to give a crash course in what the evaluation is, and how evaluators, according to best practice guidelines, are to go about it. So, when reviewing a capital mitigation evaluation, I try to start with a little teaching about what are the standards that guide this kind of work. And so it's really kind of an orientation to the reader, that we as psychologists try to follow particular standards and guidelines. These are principles in the ethics code and particularly the SGFP. And then there's also some very kind of evaluation specific guidance on whatever evaluation we're doing: competence, sanity, emotional injury, capital mitigation. And so really try to convey that to the reader, to say, look, this isn't just my opinion. This isn't what I think, Dr. Doe did wrong. This is really pulling from these standards. And what do these standards say about capital mitigation evaluations? Well, here's what they say. Legally, we know what mitigation is. So let's start with that. And then let's kind of move next to what guidelines tell us. And I think mitigation evaluations are particularly tricky, right? They are in a certain way very, very broad because it's everything that might be mitigating. In another way, they're very, very narrow because it's only information that's mitigating, and it's not addressing whole other legal issues. It's not even drudging up aggravation, right? We are to be accurate and objective about that mitigation, but it's not to include all sorts of other things. And that seems, sidebar, like that seems to be one of the main problems in mitigation evaluations, right? Is that evaluators go about them as if they were any other evaluation, or they think, well, they're supposed to be broad, so let me just include everything. Just kind of starting with an example, right? Here's that common scenario where Dr. Doe's evaluation reaches far beyond the psycholegal question of mitigation to address other legal issues. This violates a core ethic of forensic evaluation, i.e. that evaluators address only the legal question. And so just trying to walk through that and anchor that in the SGFP. And then the rest of a report like this would go on to a kind of quote from the report, the places in which this evaluator went way beyond the referral question or included information that was just either grossly irrelevant or contradictory to the mitigation question. Yeah, some of these have some pretty outlandish examples, and I think for the sake of discretion, I'm not sharing those, but hopefully you get the gist of this here. Also, just want to mention quickly another example that I alluded to earlier. This was a scenario in a capital case where the records, you did not have to work hard in these records, and it is clear that the original evaluator had these records and could have found 4 IQ scores, 3 of which looked pretty credible from school psychologists, et cetera, falling below 70, but 1 falling above 70. And in this evaluator's report, an initial testimony mentioned only the score that was above 70, and gave some other kind of similar language, like no prior testing suggested intellectual disability or scores in the intellectual disability range. And you all kind of, we all kind of cringe, like if we discovered that in the record base, but we'd also want to be able to explain why that's a problem. So, it's a failure to review or report relevant data from records, and that violates key principles of forensic evaluation. Here's again kind of quoting chapter and verse. We could also wonder if that was intentional, and I think it's a kind of delicate balance in these reviews. It certainly looks suspicious. I'm reluctant to claim that I know for sure when something is intentional or not. But if it was, right, or even if it was negligence that was kind of one-sided, there are kind of key principles in our SGFP as well that speak to these, right? This aspiration for impartiality and fairness. There's often much to say, and I think one of our themes is just kind of rooting these critiques in truly accepted sources and guidance, and you'll see those in your reference list here. So with that, let me pause, and Anthony will take over.
Yes, thank you so much, Dan and Lucy. I'm honestly surprised that we have not been having conversations like this in the field. It seems like this is something that we should have trainings and have had conversations about for quite a while now. So I'm very, very thankful for both of you sharing all of this with our audience. We have a lot of questions here, and I will do my best, the best that I can, to get to a couple of some of the common themes. Yeah. The first one I'll throw out there is any particular guidance of how you handle critiquing a report that is coming from a professional that clearly has different training or experience than you, even though you're addressing the same issue. The person brings up the example of a psychologist versus the report coming from a psychiatrist that's doing diagnosis, or doing a neuropsychological report, even if you're familiar with neuropsychological testing, but not a neuropsychologist yourself. Any advice of how you would approach that?
Well, I mean, one is to make sure you're within your own competence, right? Like I have no business critiquing a neuropsychologist on neuropsychology practice. I have no business critiquing a psychiatrist on medication decisions or anything of that sort. I think, if you draw this Venn diagram and there is an area of overlap where your work should be the same, you have similar training and there are similar standards and guidance to cite. An easy example might be something like a competence evaluation, right? I would feel perfectly fine talking about a psychiatrist approach to a competence evaluation, as long as there were not some kind of medical issues there where I'm lacking. But whatever that crossover in the Venn diagram is, I think is probably fair game.
Okay. We got several questions about the information that you might get or not get, and kind of got the opposite question. So I'll just throw all of these together at once. Some people asked about in situations where you're asked to do this evaluation and you get the report, but you don't have access to any of the raw data, notes, or anything like that. But then also the flip side, if somebody's been asked to do an evaluation about somebody's consultation, where you do have access to their notes, but you don't actually have a report. How might your process change with that?
Yeah, so I think if you just have the report, it's just going to limit what you can say. There can still be plenty to kind of critique or evaluate in a written report, but you're not going to be able to catch some of those potential issues or problems of filtering of evidence or failure to, find things that are in the record or errors in kind of testing administration. You're just not going to know those things. And so you can say that in your report, you can say, I don't know XYZ. I mean, an example I can come up with is a case where somebody gave a lot of neuropsych testing to a recent immigrant who English was not their first language, and there was no comment at all about what language it was administered in or if there were any accommodations or anything like that. So, and no different norms, really nothing about kind of cultural questions or considerations with testing. And so since there was no information, I couldn't say they did it wrong. I mostly would say, hey, these are the things you need to think about. And we don't know one way or the other whether there was kind of on the fly accommodation or whether the person's English proficiency was leading to lower scores versus actual abilities. We don't know, but this is a potential question or issue. Dan, do you have thoughts about the other one where you don't have a report, you just have the raw materials?
Yeah, reviewing somebody's work but not a report was the question.
Right. So maybe a consultation, for example, that doesn't have a formal report written to it, but has all the procedures and everything documented.
Okay, so procedures are documented. I mean, I think the short answer is you address what you can and not what you can't, right? So maybe that consultation, maybe we're just seeing a list of procedures and we don't see the person's conclusions. then I think we're limited to saying, hey, are these procedures reasonable procedures to answer the referral question with which this evaluator was posed? Do these comport with what our practice guidelines would say you should do in a, say, sanity evaluation or whatever it may have been? I mean, that's fair game. But I think that's probably the most I can say in a general sense about the question. Yeah.
Now, one obstacle to access could be outright resistance from the other evaluator. And so we did have some questions about how often have you seen this come up where the other evaluator who's being evaluated is actively resistant in terms of sharing materials, and how do you handle that in your report if you're trying to do an evaluation and you feel some limitations because the evaluator has basically, in your perspective, is resistant to cooperate?
Yeah. Well, I mean, I think the first answer is right. That's never our fight, right? There are always other agents in the legal system that are handling that. So I've never been on the phone calling the evaluator saying, hey, come on, send me your notes. I don't care if they're messy, send them. That is always handled, by attorneys and subpoena and whatever the appropriate mechanisms are. So I don't know that I've run into that much. I've occasionally had scenarios where I get a batch of records that seem suspiciously slim. Like, really, you're saying you talked for all these hours and there's these 3 messy pages with shorthand, things that seem suspiciously slim or sparse. But I don't know that I've ever had to handle a hold up. And of course, that's just not our place. I think there too, we just kind of comment on requested X but didn't get it, sort of like in a forensic evaluation, right, where you call this collateral 16 times and never get the call returned. You mentioned that, and I think it's the same way here. I wanted to review X materials but never received them. I don't know, maybe there are times where you say, I don't know why. I don't know if those don't exist or if they've not made it to me, but typically evaluations would include such and such.
I think you get the opposite too, where the attorneys give you information that the original evaluator didn't have. And so it's just very important to keep that clear in your report where, they can only work with the information they had. Maybe they were wrong to not ask for something or not get it or something, but you need to be clear about, that they didn't actually know this or have this at the time.
Yeah, that's great.
Two specific examples that someone inquired about recommendations for some scenarios. One being that this is a little bit more of the focus on the evaluator, that through your evaluation, it appears that they claim to be board certified, but you discover they're from a diploma mill or know that their license has been suspended. So how you would actually approach commenting on somebody's potential either misleading or concerning qualifications. And actually, I'll just leave it at that.
Yeah, we talked about that a fair bit of criticizing someone's qualifications or credentials is only, I don't know if only is the right word. It is most relevant when there is some failure in what they actually did because of their lack of qualification. So, if you say I'm board certified, but then it lapsed or something, but the evaluation is good, the report is good, I would maybe put it in one sentence. I don't know, but I certainly wouldn't kind of focus on it or harp on it because that is really that kind of ad hominem thing again. But there are situations where someone's lack of credentials, I think, can be really important. Recently had a situation where I was looking at an interrogation where the lead interrogating police officer had recently gotten some psychological training and was maybe in a PhD program or maybe had gotten his PhD. It was kind of unclear. And there was just a lot of talk about, him saying, oh, hey, I have a PhD. I'm an expert in behavioral lie detection. I can tell when somebody's lying because I have this psychology training. So in a circumstance like that, it's more relevant to say hey, this isn't a very good, this isn't a very well-respected program. It looks like this person doesn't actually have their degree yet. Besides, nobody can do this, even if you have psychological training. And so certification can become more relevant there, but I guess isn't our go-to of what to criticize.
Yeah, I think, and maybe this gets to the point of going out on the limb too far. Part of my, I guess, calculus for that kind of thing is what is the evaluator portraying about his or her credentials. And so, if you have a scenario where somebody has 16 publications in the same newsletter, and they say, hey, I've got a lot of scientific publications, I'm a researcher, I think it is fair game to say, and again, I kind of try to think of all this in terms of teaching. Like, attorneys who review that CV don't really know the difference between Law and Human Behavior and Criminal Minds Weekly, And so it is important to say, hey, this looks like a self-published newsletter. This is different from a peer-reviewed scientific journal. I think that's fair if somebody's purporting that. But if Dr. Doe has, just put all the newsletter publications on the CV and never made a thing of it, I don't know that it's my place to say, oh, what a poser, putting newsletters on your CV. That's not the same as a big, American Psychologist publication. But if somebody is kind of purporting more than is there, and maybe the board certification is, I think maybe an example here, if somebody was citing sort of a vanity board as a marker of great expertise, I think it is fine to address like the distinction between that kind of board and the ABFP. I have historically done that a couple times, but just by providing attorneys materials, right? Like, it just because they don't necessarily know. And so, hey, just so y'all know, there's a variety of boards out there that have different mechanisms. Here's the internet story about the guy who got his cat certified with such and such board. Here's the website for the AFAP. These are different things. Do with this, attorneys, as you will.
Absolutely. I'll throw out one more question there for the sake of time. Someone asked, particularly considering the adversarial allegiance or the appearance of adversarial allegiance, what are some unique considerations when you're doing this kind of evaluation directly for the opposing side of an expert?
I think one Lucy modeled really well, right? Like, she is taking active steps to not have her report abused. And again, I'm not sure the attorney was delighted with all those caveats, but you could see a proactive effort there to say, look, I'm going to give you a fair and vigorous critique of a bad work product, but I want to be clear that you can't, I'm not concluding the opposite about the legal issue. I can't speak to that. You'd need to get a full evaluation for that. So I think some sort of proactive clarification like that is helpful. I've also, not so much in reviews, but if I am doing a second evaluation and reach a different opinion, I will sometimes try to explain why. Basically, like, hey, reader, I know this is sort of fishy, that the public has good reason to be suspicious when an evaluator retained by the opposing side finds a different conclusion. Let me kind of walk through with you some of the strongest factors, in my opinion, right? One was that this defendant had been delusional about the first evaluators and so wouldn't speak to them. He spoke to me about how they were in his delusions. Things like that, that really just kind of help, I think, acknowledge, right? There's reason for skepticism, ask these questions. We welcome that, that's fine.
Well, Dan, Lucy, thank you so much for this very thorough and engaging conversation. I'm sure our audience has gotten a lot out of this, and I also appreciate the center on kindness and thinking about that you're evaluating the evaluation more so than the evaluator, and to be thoughtful but also honest and clear on everything for the sake of the field.
We just realized there were like 500 people who could be critiquing us, so we tried to emphasize that. Yeah.
Absolutely. And, doing that thoughtfully and compassionately, of course. That wraps up this week's Law and Mental Health series. Thank you so much for attending, and we hope to see you next week. Have a great rest of your day.
Thanks, Anthony.
Bye.
Absolutely. Take care.